Division 1 is now in session.
Thank you. Please be seated. Good morning. We are here for oral arguments in CV20 0336. It's Humphrey et al., the SWC. A couple of housekeeping items as we get started here. In more normal times, we would invite you to stand at the pulpit here during your oral arguments. These are not those times, so we will invite you to just stay seated at council table there throughout argument. As you can see, our panel is physically distanced, and we have removed our masks to make it easier for us to communicate with you. If you would like to, you're welcome to remove your mask during your argument. Of course, if you're more comfortable keeping it on, you're welcome to do that as well. These proceedings are being video and audio recorded and live streamed, so we ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if desired. You might have to stand up out of your seat to be able to see that clock there. Also, please keep in mind that we have read the briefs and have conferenced the case this morning. And with that, counsel, you may proceed.
Thank you. Good morning, and may it please the court. My name is Eric Stanley, and I represent the appellant Scottsdale Worship Center. This court should reverse the Superior Court and direct that summary judgment be entered in favor of the church for two reasons. First, paragraph 4 of the CC&Rs applicable to the neighborhood do not apply to the church's proposed use. And secondly, in the alternative, should this court hold that they do apply, the plaintiff's claims to enforce the CC&Rs are barred by the adverse possession statute of limitations. So I want to take that first argument first in terms of paragraph 4 of the CC&Rs that do not apply to the church's proposed use. Of course, the cardinal rule in interpreting CC&Rs is to give effect to the intention of the parties. That was in the Powell case. Here we know what the intent of the CC&Rs are, and it's explicitly stated to create a, quote, choice residential district. The language used in the document...
Why doesn't Section 10 inform our analysis of the intent of the parties?
Section 10...
of the CC&Rs.
Well, first and foremost, I think it could, and it does. The entirety of the document does inform the analysis, of course, as to the intention of the parties. Plaintiffs have raised a claim specifically that the proposed use violates Section 4.
Right, but if we're interpreting the intent of Section 4, and
Correct.
we have Section 10, which says no business whatsoever, then why doesn't that help us understand what a single-family dwelling is supposed to be?
Right, I think it does, and I think in this case, of course, there is not a business that's being conducted. This is a
A
ministry.
school's not a business?
No, this is a ministry of the church. It is a church
Do they
activity.
charge for the school?
That's not in the record. I don't believe, I don't know the answer to that.
Well, and the reason I ask is sometimes people think business means for profit,
Correct.
and that's one interpretation, but nonprofits also run businesses all the time. Business is a enterprise,
Right.
and in this sense, I would think a school would fit within the definition of an enterprise.
Well, I think in this sense, it talks about no business of any kind or character whatsoever shall be conducted in or from any residence on said lots. However, it does talk about other things that are allowed. So this does inform, obviously, that there's not going to be any business located in or from any residence. It doesn't say that there should not be nonprofit activity, things of that nature. I think this is more directed toward for-profit activity. To the extent, though, that the court would think, though, that this does apply to what the school is doing, that there is a business, quote-unquote, going on in here, I think that's where our second argument would come in.
But if we pause for a moment, let's go back to that profit-nonprofit distinction.
Right.
So we could run the Humane Society as a nonprofit business out of that house, is what you're saying?
That's what I'm saying. I think it is not necessarily intended to encompass things that are nonprofit. For instance...
St. Vincent de Paul Thrift Store can go in there, and that's fine?
Well, as long as it does not affect what the intention of the parties were in the CC&Rs, which this court has held would be to not affect negatively the aesthetics of the neighborhood or the general character of the neighborhood. And that's what this court held in Burke.
And also to maintain it as a neighborhood for single-family dwellings.
Well, that's not specifically what this court held in Burke. This court did construe this exact provision, Section 4 of the CC&Rs, in Burke, and it did say, quote, Section 4 of the restrictions gives homeowners in the subdivision the ability to prevent structures on the lots that might compromise the aesthetics and the general character of the neighborhood. And that goes to how the language used in the CC&Rs. It does not expressly regulate use other than in certain instances, like the business exception in Section 10. But other than that, it does not expressly regulate use. It does so. It doesn't mean there's no regulation of use at all, because obviously the use, how a structure is used will be limited to what the structure is and the effect that that use has on the aesthetics and the general character of the neighborhood.
Do you have the site for Burke handy?
For Burke, yes, I do. It is 287 Arizona 393
Thank you.
is what that is. In that case, the court was construing the building of a cell phone tower on the lot and of course held that that was a structure that was prohibited by the CC&Rs. So,
Did you say 287, isn't it 207?
sorry, 207. I should have brought my glasses. I apologize. I forgot my glasses in the car and I'm having a hard time reading that. 207.
I'm the same way now. I can't see anything.
So in that respect, what this court talked about with the CC&Rs in Burke in terms of how those CC&Rs were drafted to affect the intention of the parties, that's what's important here. The language the parties used is important, and it did not expressly regulate use other than in minor ways and other than in self-limiting ways. What these CC&Rs are targeted at is to protect the aesthetics of the neighborhood and the general character of the neighborhood. And the facts are undisputed here that what the church is proposing to use this single-family dwelling structure for will not negatively affect either of those. The aesthetics will not be affected because the structure is not going to be changed at all. It will remain a single-family home. There will be no alterations.
Okay, so if we accept that premise, a doctor's office often operates out of single-family dwellings. They just convert them. So if a doctor's office wanted to go in there, and it's not going to change the structure, exterior of the structure at all, is that okay?
Well, I think that would be clearly a business that would be prohibited by Section 10. So I think there's a very limited exception here in terms of what is a business and what is not.
So a school is not a business, is what
A school could be a business. I think my
Okay.
argument is that in this instance, it is not, because it is a ministry of the church. So it's not for profit, that kind of thing. Is it a nonprofit, not making any money, a ministry to the community?
Doesn't that all depend, though, on a lot of stuff as far as, so for example, let's say at the beginning, they're only taking, and I'm just picking numbers at random.
Sure.
6 students. And so it's really not going to have much impact on the character of the neighborhood. And, those students won't increase traffic, all those kind of things we'd be worried about. But let's say in year 2, they decide, well, that 6 worked really well, and so now we're going to up it to 20. And 20 might really change the character of the neighborhood and the use of the building. At what point how do we draw that line?
Well, absolutely. I think you draw the line according to what the intention of the parties were as expressed in the language of the document, the CC&Rs, that if it does become to a point where it affects the aesthetics and the general character of the neighborhood, then there could be a claim under here that it does violate the CC&Rs. So there is an outer limit.
So then shouldn't we, because you asked us to reverse the grant of summary judgment to the appellees and instruct the court to grant summary judgment to you. It sounds like really it's a factual question that we need to send it back and determine whether the use of the school is going to affect the character of the neighborhood there. So why would we grant summary judgment for you instead of sending it back for a trial, basically?
Sure. So I have 2 answers to that. First, if the court's inclined to send it back for a trial, I'm all in favor of that. We have no problem with going back to establish the facts if the court feels that there's facts in the record that need to be established. But secondly, under the undisputed facts of this, the court can look at what is in the record, which is the exact limitations that are put on the school by the City of Phoenix under the zoning code. That's in the record. The City of Phoenix has limits on, and we go through this on page 14 of our reply brief, where we kind of compare what the church proposes to use versus what the church has been using, where we talk about what those limitations are. There are certain limitations for how many students can be there. There are limitations for the hours that can be operated. There's 10 different limitations that the City of Phoenix put on this school that are in the record currently that do demonstrate this does not have a negative impact on the character of the neighborhood. So I think under that record, the court could direct for summary judgment and should in the church's favor with that. The CCNRs here, if they do want to regulate specifically the use of this property, there are ways that it could have been drafted to do so. Section 4 does not do that. A good example of this is the Exchange National Bank case from Illinois cited by the appellees, where that particular restriction says the building erected on each lot shall be for residence purposes only. That's a far cry from this particular draft of these CCNRs, which are clearly targeted at just preserving the aesthetics and general character of the neighborhood, not the use other than in kind of self-limiting ways. So in that respect, our argument is that, and I'll go back one point on this, one final point on this argument. Appellees make a key admission on page 8 of their answering brief that the single-family dwelling structure on the property can be used for something different than a home for a family without violating the CCNRs. Specifically, they admit that the home can be used by the church for, quote, small group religious activity. This admission proves the church's arguments that the CCNRs don't regulate use of what happens in the home beyond kind of these self-limiting ways, and certainly ways that are consistent.
I read that concession a little differently than you, and maybe it's based upon my own personal experiences, but it's not unusual for church-going people to have Bible studies and family home evening in case of LDS families in your home, where you might invite other church members over. That's all I read that as. Are you saying that there's something more to that concession?
I am. I'm saying that the appellee's argument is that this single-family residential structure may only be used, that's their argument, it may only be used as a home for a family. That's their argument. That's what they say the CCNRs mean. That concession is that that's not true. It can be used for other things. And it can be used in that way because it does not change the aesthetics of the neighborhood or the general character of the neighborhood.
I read that as saying, or it can be used for the other things that a family would normally do if they were living there themselves. So explain to me why that's a broader concession than that.
Well, it's a broader concession than that because if their argument is, which it is, that only a family can be there and use it for residential purposes, sure, there's going to be incidental uses to that. But the undisputed facts in this record are the church used it for about 20 years without a family living there. No family at all. And there were... Right,
but their argument is, but the church's use were the things that a family might have done had a family been living there. Is it different than that?
No, my argument is that this concession is such that the appellee's argument is belied by the fact that they're saying, no, it could be used in ways other than that. And my argument then goes to, well, if it can be used for that, then why can't it also be used for another use, the church's proposed use, that does not have a negative impact on the aesthetics or the general character of the neighborhood? That's the argument.
And then how is that, going back to what Judge Campbell talked about earlier, how is that different than the doctor's office?
It's different than the doctor's office because I think in that instance it's a clear violation of Section 10. Because
so you would argue, your position would be a doctor's office would not violate Section 4?
I think it would not violate Section 4 unless there is evidence that it violates the aesthetics and the general character of the neighborhood. So if, for instance, the doctor's office were to come in and make all kinds of changes to the exterior of the building, or were to have a lot of traffic in and out that would affect the general character of the neighborhood, then yes, it could violate Section 4. But Section 4 specifically does not regulate that kind of use. That's my argument. If this court does, though, believe that Section 4 does apply, then our alternative argument is that the plaintiff's claims are barred by the statute of limitations for adverse possession. And just briefly on that, a restrictive covenant, of course, is a property right in the nature of an easement that can be adversely possessed. And the undisputed facts are that since 1999, the church has been using this property in ways that are non-residential.
Have they been using it as a school since 1999?
And that they have not.
As I read the cases dealing with adverse possession or prescriptive easement. It's a non-conforming use only provides adverse possession as to that specific non-conforming use. It doesn't waive everything that applies. Am I missing something in the case law?
So in Sabino Town and Country Estates, which is from Division 2, Court of Appeals 1996, it talks about adverse possession of an easement, the servient estate adversely possessing an easement. And it just says it has to be clear, positive, and unequivocal evidence that its use of the easement was inconsistent with and antagonistic to the easement owner's right. So the Superior Court erred in very restrictively defining this to say it has to be an identical use, school to school. That's like saying that you can't extinguish an easement on your property because you've driven Jeeps over it instead of minivans. I mean, that the law doesn't go that fine point. It doesn't require identical use to extinguish or to bar under the adverse possession statute.
So when we look at a prescriptive easement and we talk about case law that interprets that and it says not to exceed the uses through which they acquired the easement.
Right.
The church was using this for small group gatherings, say that 10 times quickly.
Yeah, right.
Small group gatherings, Bible studies, etc. How many days a week was the church using it for that purpose?
The record would show that it was continuous in the sense that it was weekly. That's all it was.
Okay, so when we look at weekly use versus daily use, do you think that is the same kind of use?
No. Well, I think it is under the adverse possession statute of limitations, because the use has to be continuous in the sense that it is ongoing, not that it has to be daily or weekly of those kind of things. There's certainly.
But there's limitations on what kind of an easement. I get the minivan versus the
Sure.
Jeep. But if we're talking about using the minivan versus semi-trucks and using it for a thoroughfare for business uses, that would be different.
And I would say my argument would be that it depends upon the nature of the easement. If it's an ingress-egress easement, that's what you look at. Was it used for ingress and egress? Not whether it was used daily versus weekly.
Yeah, but a
Ingress,
prescriptive
egress.
easement is defined by the use to which it was put.
That's
This
right.
isn't an ingress-egress easement. So if you have.
Correct.
If you establish an easement, I agree with you 100%. You drive that Jeep over there twice a
Right.
week, and then you switch to a minivan, who cares? But if you switch to keeping the Jeep, but now you're driving it 25 times a day and pulling a trailer, that's a different thing, isn't it?
Well, and I think that's where the court has to look at what is this particular restriction? What is this negative servitude that's on the property in the CC&R? It is, according to the appellees, that this house may only be used as a residence for a family. That's it. And so our argument is it hasn't been used that way for over 20 years. It's been used in different ways than that, and in ways that are inconsistent and antagonistic to that, because there have been many of those years where it hasn't been used as a residence for a single family at all. And even in those times where it was used as a residence for a family, it was still being used for kind of these small group religious activities. So in that respect, our argument is that they were on notice and they should have known for the last over 20 years that this particular use was antagonistic to the CC&Rs as they interpret them and as they've asked the court to interpret them. I see I've got a few minutes left. I'd like to reserve the remainder of the time for rebuttal if possible.
Thank you.
Thank you.
Thank you.
Thank you, Your Honor. I'm Timothy Lasota on behalf of the plaintiff appellees, Patricia Humphrey, who's here in the court today, and James Burke, and may it please the court. I think that, we really have to go back to, first and foremost, Section 4, and it says, quote, one detached single-family dwelling. And now, according to counsel, a doctor's office where nobody lives. It's now a doctor's office. That is now a single-family dwelling. It cannot be a single-family dwelling if it's a doctor's office. The fundamental flaw.
I'd like you to start right off. Why did you not use paragraph 10 of the CC&Rs as your linchpin to your argument?
Well, Your Honor, the reason was because I think it's a little bit more convoluted of an argument, because I knew the argument would be, well, this is a school, it's a ministry, it's part of the church. I think Section 4 is the better one, but I do agree Section 10 does inform this court. I think that St. Vincent de Paul came up, and that's a ministry of the Catholic Church, but it doesn't make it it doesn't make it any less a business. It clearly is a business. I think Section 10 does inform, but I think at the end of the day, when somebody, no matter what something used to be or what something was built for, when it has been turned into a different use, it is no longer what it used to be. It's the new thing. This is a school. It is not a detached single-family dwelling. Now,
You would agree, Mr. Lasota, that the use to which it's been put has not been single-family for the last some period of time, longer than the adverse possession rules.
No, Your Honor. I think that in the record, it has been a single-family residence for much of the time.
But no family's been living there for this period of time.
Your Honor,
Ma'am,
I don't think that's...
do not speak.
Your Honor, I don't think that's correct. I think that there was a family living there. I think there have been multiple families living there. I think the Bakeys live there. Now, I do agree they have used it for small group religious activity, but using a home for Bible study is consistent with a residential use. That's essentially what it's been used for. You can have a Bible study at your house, and that does not change it from a house to something else. It's still a house. It's still a residential dwelling.
So, Mr. Lasota, you're saying, and I know that in the record they talk about certain families living there using it kind of as lodging but for the last 20 years, it's been used not exclusively as a single-family dwelling. Do you agree with that or not?
No, Your Honor. I think there have been other. If you want to call a Bible study and things like that a non-single-family use, then I would agree with your premise. I don't think it's been continuously used for anything but a residence. I think it's accurate to say that.
So, excuse me, ma'am, I appreciate that this is an emotional day for both parties, but we're hearing argument from your attorney. So you're welcome to stay in the courtroom, but if you speak again, we're going to ask you to leave, okay? Go ahead, Mr. Lasota.
Okay, but it certainly hasn't been continuously occupied for anything like that anything other than a residence with the incidental use for the last 20 years.
So I don't see the record supporting that it has been occupied as a single family, but it has been occupied as a residence for the last 20 years. So is that your argument, that over the course of the 20 years, somebody has consistently been living there and Bible study was incidental to?
Yes, Your Honor. And I'm not saying that every single moment in that 20-year period somebody has lived in that house, but it generally has been lived in by people. There was a family there, the Bakeys. I think they had some people working at the church at the time who lived there, and that is the record. That is in the record. I don't think that we can, that there's necessarily an accounting for every single 20 years, but it's been used as a house with incidental Bible studies and small group religious activities there.
It seems to me that we're kind of conflating or maybe kind of mixing issues here. So the first issue, as I see it anyway, is does it violate Section 4, which is the claim that you guys raised. So regarding a single-family dwelling, if the record's unclear, why wouldn't it be back to the trial court to figure out whether the use proposed is of a nature that is going to be change what would otherwise be used by, or change the impact on the community in a sense that would be inconsistent with a single-family dwelling?
Well, Your Honor, I don't think there's any need to get to that point because just as a doctor's office is not a detached single-family dwelling, a school is not a detached single-family dwelling. I mean, the irony in the defendant's position is they want to go to this more vague language about, well, it's supposed to be a choice residential district, and that means something, and if you violated that, then come into court and you've got a great case. But somehow these much more explicit provisions, one single-family detached residence or dwelling, somehow that's too vague to understand, and that now accommodates a school.
Mr. Lasota, let's just, if you had to name paragraph 4, that's a structural restriction. It says single-family dwelling. You can't build multi-family use properties. You can't build office buildings. You can build a guest house to house your domestic assistants. which tells you how long ago these were written. But when we look at paragraph 10, that seems to address more directly the use restriction. So you talk about a single-family dwelling. A school can be operated out of a single-family dwelling without changing the exterior of the structure. It's the use that you keep arguing in, and when we conflate the two, it becomes confusing. So can you address that point?
Your Honor, I do think it's an excellent point on paragraph 10. This is clearly a business, and section 10 does prohibit businesses also. Now, and I think if you look at the document as a whole, I mean, this business about how they're interested in preserving the intent of the residents, that's not true. We already had the one case where they tried to put a cell tower. I mean, they consistently try to put a square peg in a round hole, and it never works. You know, when we talk about, now I raised the issue, the other problem is defining something. I mean, they keep calling it a single-family dwelling, and what about the structure is a dwelling? It's not. A dwelling is where people live. The trial court correctly found that, and she found simply a school is not a dwelling. Now, it is true that you could change a house into a doctor's office or a business, but I think that no longer is still a dwelling. Then the Taco Guild is still a church. But to the extent there's any doubt, I do think Section 10 does go to the intent of the drafters of that document and does bring you home to the point that, look, this is meant to be a residence. And I know one of the members of the panel made the point, look, if a small school, why not a large school? And that is absolutely true. They over and over again, they call it a small school. And if a small school is allowed under these restrictive covenants, there is not one thing in there to limit it to a large school other than this more general language about choice residential district, which somehow should mean something when all the other words in there don't mean anything.
Can we go back to single-family dwelling? What does that mean to you?
A single-family dwelling is a place where people live.
All right. So
A single family also, Your Honor. Another problem with their argument.
Okay, so here's my question. Let's say I purchased this house and I have just graduated from college and I have my girlfriend move in with me and another person move in with me, and we're not a family. What defines family? But we are all living there as roommates. Does that run afoul of single-family dwelling?
Your Honor, I think technically speaking, I think that does run afoul of single-family dwelling. I do think there may be some, I think the courts that have interpreted that have generally given a fairly liberal construction to what's a family. But I think when you amalgamate people who have no sort of, well, just, and that's, I mean, here we're not even talking about friends in the same building. We're talking about different people who go to the school. I mean, at least you could say, well, we're a family. I consider this person family. I've been friends with them forever. Maybe you could get to family with that fact pattern, but these are people who presumably don't know each other who show up to the school. So I don't think it meets single family, and I don't think it meets dwelling, and it's a business.
Earlier I said the analysis in my mind is two parts. Let's turn to the second part, which is the adverse possession. Is there a factual dispute as to how this place was used over the last 20 years?
Your Honor, there is a factual dispute, but I don't think I don't think it precludes this court from affirming the trial court because it's not technically relevant. I do think it would preclude this court from just telling the trial court to grant summary judgment to the defendant here, but it essentially centers around how exactly the house was used. And, to be perfectly honest, and this goes to the open and notorious element of adverse possession, that, look, it's got to be open and notorious. Why? Because it's a matter of fairness to the person whose rights are going to be extinguished if this adverse possession goes any further. So it's not, in this case, I don't know exactly how they used the house. I mean, nobody counted the number of people who went in there and were participants in the Bible study. They've called it small religious group activity, and I think that I think that's probably accurate, but I don't know how we could say otherwise anyway. And that goes to open and notorious. And how in the world you get from, we're going to have small group religious activities, so now you're on notice that this is going to be turned into a school. How do we get from A to B there? We don't. That is not the type of open and notorious use. The panel already focused on, some of the cases, and they say, you get that use as far as that use goes and nothing more. I mean, you use this path to get from here to there. That doesn't mean you get the house that happens to be on the same parcel. I mean,
Well, but if Mr. Lasota, if the school or if the church was having Bible study there, 3 different Bible studies meeting each day, just picking stuff at random, is that different than what would be going on in a school, such that could create, or not different than what would be going on in a school, such that it could create an easement to use the school or a prescriptive easement to use the building in that regard?
Your Honor, I do think those things are different. For example, the reason that the neighbors, what the catalyst for opposing this was that under the Phoenix City Code, which in their brief, they told us that zoning was important because zoning, if you don't worry, you can negate these restrictive covenants because the zoning code still protects the neighbors. Well, under the zoning code, when you want to operate a school, you have to go and you have to apply for either a use permit or a reasonable accommodation. It's basically the same thing. It's a different label. There's actually a public process you have to go through to obtain that, and that essentially puts the neighbors on notice. If you want to have Bible study in your house, even if it's zoned residential, you don't have to go get a use permit. You don't have to do anything. You can have a Bible study, and if you happen to be very religious, I think you can have it as many times a day in your home as people are interested in coming. But I don't think that changes it from a residential use to something else. That's Bible study. People can have Bible study in their homes. It's still a residential use. I mean, people use their yards to cook. They've got a barbecue. That doesn't make it a kitchen or a restaurant either. I mean, there are all kinds of uses that are incidental to residential uses that do not change the fundamental aspect of the use.
Well, but my experience with Bible study, and I'm not saying that's what's in this record, is that you have someone who is almost acting like a teacher who's kind of prepared a lesson or a plan, and they're kind of guiding the discussion, and there might be a group of 8 to 10 people there discussing it, listening to the lecture, commenting, very kind of similar to what you'd see in a classroom. And if they were doing that in a manner sufficient to kind of mirror what was going on in a school, why would that change the use of the building if you now have, 6 to 8 students coming in, sitting in a classroom, listening to a lecture on whatever the subject is? Why is that different?
Well, Your Honor, I think one thing that's different about it is you've got an open and notorious problem. So, I mean, there's no way for anybody to know what's going on within when people enter a house, they said small religious group activity, we sort of have to accept them at their word. So if they're operating something that is more akin to a school, how's anybody gonna know without being inside that room? So I think you've got an open and notorious problem right there. You're right. There are certain things that are similar to. Take for example, a lot of kids in COVID have been learning from home, and what some people have done is they've because it's difficult for people to necessarily be home and guide the kids. I mean, they've said, well, you can drop your kids over at our house, bring your laptop, and you can be online. Now that doesn't, that may happen, but that does not transform that house where people actually live into a school. It just doesn't. These things are different. I think you get back to, obviously there's Section 10, is it a business? Now we're talking about the use, but I think this is still relevant, it's supposed to be a single-family dwelling, and if nobody lives there and instead it's used for another purpose, a doctor's office even, then how is that a dwelling? It's just not, no matter how many times we call it a single-family dwelling, a place that houses a doctor's office, a school is not.
Is there anything in our record regarding what type of changes they may have made to the internal structure in order to make it accommodating of classroom instruction?
Your Honor, I don't think there is anything in the record to that extent. I think the record, to the extent that it informs this, it does talk about the structure in terms of how it looks from the outside. And I think that is but I do think that the fundamental flaw in the defendant's argument is that, use is defined, what something is defined by what it used to be or what it was built for. It's not. What something is defined by what it is today. Just as a house that used to be a doctor's office is now a doctor's office. I mean, no one would ever say, I'm going to go to that house. When they mean I'm going to my doctor's office, they would say I'm going to the doctor's office. Nobody would say if they're going to a bar restaurant that they're going to a church. So I think these words, at the end of the day, these words matter. They convey the intent of the people who signed them that, look, we want this to be a single-family residential district. And by the way, there's an amendment process built into the CC&Rs. We know from here that the defendant tried that and it failed because they asked for an extension for their brief. So they could go out and try to collect signatures to get people to agree that they can have a school, which is sort of an inconvenient element because they supposedly can already do a school. So to the extent that the neighbors, what they think this matters.
Their attempt maybe to avoid the cost and delay of litigation doesn't necessarily seem to me to be a concession of anything. So I would suggest you move on from that argument.
Okay. Well, Your Honor, at the end
I've
of
got one more question for you, and you're running out of time, so I want to make sure I get this out. Isn't it true that the church has been using the surrounding portions of that property for overflow parking for the church services for a number of years, if not more than 10?
Your Honor, I believe there was an agreement. This was pursuant to another lawsuit that did allow them to use some of the overflow parking for parking during certain specific hours.
So let's talk about that other lawsuit. That occurred in what year?
I don't remember the year, Your Honor.
But it would add to it would run afoul of your notorious argument when they've been using it with a use inconsistent with a single-family dwelling by using it as a parking lot, correct?
Your Honor, I don't think it runs afoul of it because I think that was a separate agreement that frankly could have been challenged by one of the other neighbors at the time. And I think that the fact that they park cars, I think if we were challenging their ability to park cars, I think that would be relevant, but we're not. I mean, that aspect of it is there was a concession made to them on that point, but the CC&Rs themselves contain a provision that, look, just because one part of this has been sort of negated by use, it doesn't mean other parts are, and I forget which section, I think it's at the end, but it doesn't mean other parts. So I would say even if that particular thing is inconsistent with a residential use, it doesn't destroy the rest of the CCRs and the rights of those who sign the covenants and restrictions to have the property used only for a single-family residence.
Thank you, counsel. Time goes quickly.
Thank you, Your Honor.
Just a few points, just a couple of record points. Judge Campbell, your question about the parking that was in 2007 was when that settlement agreement was entered between the parties. And then Judge Morris, your question about the changes to the internal structure of the house, I would refer you to record document number 27 at paragraphs 22 and 23, which specifically discuss how the church picked this residential facility because of its residential internal parts, the bedrooms, the kitchens, the things of that nature, to teach the autistic children residential daily living skills. So that's the record evidence about what's going to go on internally in the House. One point about Section 10 of the CC&Rs, because the court has asked some questions about that. As I've argued, I don't believe that this falls under the business prohibition in Section 10 because this is not a business, it's a nonprofit ministry. What this might fall more appropriately under would be the prohibition in the CC&Rs prohibiting anything related to the care or treatment of the sick and disabled. But that provision has been held to be unenforceable, and we cite on page 3 of our reply brief the Westwood Homeowners Association case at 155 Arizona 229, where that provision has been held to be unenforceable as a violation of the Arizona Developmental Disability Act. And so it's, again, the language of this, it may more appropriately fall under that as opposed to.
Case also says that when you have an unenforceable provision combined with enforceable provisions, it's severable, right?
That's right.
Okay.
And the CC&R document says that as well. My point is that it would not fall under the business. If it does fall in Section 10, it's more appropriately directed at use, it might fall under that provision that's been held to be unenforceable.
So if we agree with you that business versus not-for-profit business,
Right.
they're not the same thing, and I don't think you've gotten me there yet. Address that point.
Sure. This was intended, and there is a lot of case law about what is a business, what is not a business, this kind of thing. This is more akin to a residential care facility, which is normally allowed in residential areas specifically because of the residential nature of what's going on in that facility. This is not a for-profit enterprise. It's a nonprofit ministry of the church to the community. So that's a key distinction.
A soup kitchen would also be a nonprofit ministry. Would that be allowed?
It would be, and I think it could be allowed if it did not affect, it would not be a business, and if it did not affect the aesthetics and the general character of the neighborhood. So it might very well, if you've got people, tromping in all day and all night and, that kind of thing, and it becomes more transient in nature, then it might affect the aesthetics and the general character of the neighborhood. I see my time's expired. Thank you.
Time is up. Counsel, we thank you both for your argument. You've given us much to think about. We will take the matter under advisement and issue a ruling in due course. And we are adjourned.